In California, more than 1 out of every 5 home foreclosures no longer starts with a missed mortgage payment. In recent years, thousands of homeowners have lost their houses over small, unpaid bills, technical violations, or paperwork mistakes, sometimes for amounts under $1,000. Even more shocking, many of these people only realized something was wrong after legal notices were already issued. The idea that, as long as you pay your mortgage, your home is safe, is no longer true in modern California law. Here's the uncomfortable question. What if your home could be taken even when you're doing everything right? No job loss, no loan default, no warning phone call, just a letter, a lien, and a legal process already in motion. New and expanded California laws now allow cities, counties, HOAs, and state agencies to stack penalties, convert fees into liens, and force property sales quietly, often targeting ordinary families, seniors, and longtime homeowners. In this video, we're breaking down 10 shocking California laws passed or expanded for 2026 that could legally put your home at risk. Most people have never heard of these rules, yet they are already being enforced. Stay with us until the end, because one of these laws could apply to you right now, without you even knowing it. Number 1. Property tax foreclosure expansion. California law now allows counties to take your home over surprisingly small, unpaid property tax balances, and the rules are becoming stricter heading into 2026. In many counties, if property taxes remain unpaid for a set period, often 5 years or less, the home can be placed into a tax-defaulted status. What most homeowners don't realize is that interest, penalties, and administrative fees compound aggressively, turning a few $100s into a devastating legal threat. This process does not require a missed mortgage payment, job loss, or court conviction, just unpaid taxes. What makes this law especially dangerous is how quietly it works. Notices are typically sent by mail, sometimes to outdated addresses, inherited properties, or homes owned by seniors who may not regularly check official letters. Once the deadline passes, counties gain the authority to auction the property, often selling it for far less than market value. In some cases, homeowners lose all equity, meaning decades of hard work can disappear over a tax bill smaller than a monthly car payment. The most alarming part is that many people could have prevented this loss with simple actions. California does allow payment plans, tax deferrals for seniors, and hardship exemptions, but these protections are not automatic. You must apply for them. If you ignore or miss a notice, the system keeps moving forward without you. This law doesn't target reckless homeowners. It affects people who are uninformed, overwhelmed, or temporarily struggling. Understanding this rule early can be the difference between keeping your home and losing it forever. If this law surprised you, pause and tell us in the comments. Which bill amount do you think should never put a home at risk? Your opinion matters, and we read every single one. We put serious time and research into exposing laws most people never hear about. So support our work by subscribing. It's just one click, and it helps us keep these videos coming. Number 2. Utility bills turned into property liens. In California, unpaid utility bills can now quietly put your home at risk, even if the amount seems small or disputed. Charges for water, sewer, garbage, storm drainage, or fire services are no longer treated like ordinary monthly bills in many cities. Under expanded local authority, these unpaid fees can be converted into property liens, attaching directly to your home. Once that happens, the debt is no longer just a bill. It becomes a legal claim against your property. What makes this law especially alarming is how easily it can spiral. A missed payment during illness, travel, or financial stress can trigger late fees, penalties, and administrative costs. Over time, cities can add these charges to your property tax bill, which means failure to pay can eventually lead to tax foreclosure proceedings. Many homeowners assume utility shutoff is the worst-case scenario, but under these rules, the real danger is losing ownership, not just losing service. This law often hits seniors, low-income households, and inherited properties the hardest. Bills may be sent to outdated mailing addresses, or services may continue running in vacant homes without anyone actively monitoring them. The most frustrating part is that many cities do offer hardship programs, payment plans, and billing disputes, but homeowners must proactively request them. If you don't respond in time, the system keeps moving forward automatically. A utility bill you barely noticed can quietly turn into a legal pathway to take your home, making awareness and early action absolutely critical. Be honest in the comments. Did you ever imagine a utility bill could put your home at risk? We want to hear your thoughts, because real experiences help everyone watching. We put deep research into uncovering laws like this, so support the channel by subscribing. It's just one click, and it helps us keep exposing what most people never see. Number 3. City code violations that turn into forced home sales. In California, something as small as peeling paint, overgrown weeds, or a broken fence can legally snowball into a threat against your home. Under expanded code enforcement authority, cities are allowed to issue fines for property violations that many homeowners don't even realize exist. These fines are often charged daily, meaning a minor issue can turn into thousands of dollars in penalties within months, without a court hearing or criminal charge. What makes this law especially dangerous is how fast fines become liens. Once violations remain unresolved, cities can record a code enforcement lien against your property. That lien accrues interest and blocks refinancing or selling your home. In extreme cases, cities are legally allowed to force a property sale to recover unpaid fines. Many homeowners assume these notices are warnings or suggestions, when in reality, they are legal countdowns already in motion. This law disproportionately affects seniors, disabled homeowners, and people living on fixed incomes. If you're unable to physically complete repairs or afford contractors, the fines don't pause, they multiply. While cities often advertise compliance periods or extensions, these protections usually require formal requests, inspections, and documentation. If deadlines are missed, enforcement continues automatically. The most shocking part is that these cases rarely make headlines, yet they happen quietly every year. A home that's been owned for decades can be lost, not because of debt or crime, but because of bureaucratic violations most people never knew could cost them everything. Take a moment and comment below. Do you think a small property issue should ever lead to losing a home? Your answer might surprise others watching. We put real effort into uncovering laws that stay hidden from the public, so support us by subscribing. It's just one click, and it helps us keep exposing what truly matters. Number 4. Abandoned property, rules that can strip ownership. California's expanded abandoned property rules are one of the most misunderstood and dangerous laws heading into 2026. A home does not need to be vacant, falling apart, or unpaid on its mortgage to be labeled abandoned. In certain situations, counties and cities can presume abandonment based on missed mail, unpaid fees, lack of visible occupancy, or extended absence due to illness, travel, or legal delays. Once that label is applied, protections homeowners normally rely on can quietly disappear. What makes this law alarming is how quickly the process accelerates. After a property is flagged, local authorities may move forward with expedited enforcement, attaching fines, securing the home, or adding maintenance costs to the property record. These costs then become liens, and if they remain unpaid, they can trigger foreclosure pathways similar to tax-defaulted properties. Homeowners often assume that ownership alone protects them, but under this rule, absence can be interpreted as neglect, even when it's temporary or unavoidable. This law is especially risky for seniors in hospitals, military members, out-of-state property owners, and families handling probate or estate transitions. A home can sit in legal limbo while paperwork moves slowly, yet enforcement timelines move fast. While appeals and occupancy declarations exist, they must be filed promptly and correctly. If deadlines are missed, the system doesn't wait. A home that's been legally owned for years can be treated as disposable, not because it was given up, but because someone wasn't physically present to defend it in time. Let us know in the comments. Should time away from your own home ever put ownership at risk? Your perspective could open eyes for thousands watching. We spend countless hours researching laws most people never hear about, so support our work by subscribing. It's just one click, and it keeps these videos coming. Number 5. Rental law penalties that can put your property on the line. California's expanding rental regulations don't just affect tenants. They can seriously threaten property owners as well. Under newer enforcement rules, landlords who violate rent caps, eviction procedures, registration requirements, or even paperwork deadlines can face steep fines. What many small property owners don't realize is that these fines don't stay as simple penalties. If unpaid, they can be converted into legal liens against the property itself, opening the door to forced collection or sale. The danger lies in how technical and complex these laws have become. A missed registration renewal, an incorrectly worded notice, or a delayed response to a tenant complaint can trigger enforcement actions. Cities and state agencies now have broader authority to stack penalties, meaning multiple violations can be charged at once, even if the mistake was unintentional. Over time, these fines grow with interest and administrative fees, turning a manageable issue into a serious financial threat tied directly to your home. This law hits small landlords and accidental landlords the hardest, people who rent out a single unit, an inherited home, or a converted garage to help cover expenses. Many don't have legal teams or compliance experts monitoring rule changes. While appeals, corrections, and grace periods sometimes exist, they usually require quick action, documentation, and legal awareness. If deadlines are missed, enforcement continues automatically. In the worst cases, unpaid penalties can lead to property liens, blocked sales, or court-ordered actions. A home meant to provide stability or extra income can suddenly become the very thing that puts ownership at risk. Drop a comment and tell us, should paperwork mistakes ever threaten someone's home? Your answer helps others see the real impact of these laws. We put real time and effort into breaking down rules like this, so support the channel by subscribing. It's just one click, and it keeps this information alive. Number 6. Unpaid state fines and court judgments that attach to your home. In California, unpaid state fines, civil penalties, or court judgments can quietly become a direct threat to your home, even if the case has nothing to do with housing. Traffic-related fines, civil lawsuits, code-related penalties, or administrative violations can all result in judgment liens. Once a judgment is entered, the state or a creditor may legally attach that debt to your property, turning a personal issue into a property-level risk. What makes this law especially dangerous is how automatic the process can be. Many people assume a fine only affects their credit score or bank account. In reality, once a judgment lien is recorded, it locks onto your home's title. That lien earns interest, blocks refinancing or selling, and stays in place for years. If the amount grows large enough or remains unpaid, creditors can push for forced sale proceedings, even when the original issue was relatively minor. This law often affects people who are already overwhelmed, those dealing with medical bills, legal disputes, business fines, or family court matters. Notices may be missed, misunderstood, or ignored under stress, yet the legal clock keeps ticking. While California does allow payment arrangements, lien releases, and judgment challenges, these options usually require timely action and formal filings. If deadlines are missed, the lien remains active and powerful. The most unsettling part is that homeowners can lose control over their property without ever stepping into a courtroom about their home itself. A non-housing mistake can quietly follow you for years, until it finally shows up as a threat to the place you live. Comment below, should a fine or lawsuit unrelated to housing ever put someone's home at risk? Your voice helps start conversations people avoid having. We spend serious time researching laws like these, so support our work by subscribing. It's just one click, and it helps us keep bringing these issues to light. Number 7. Fire safety and insurance rules that can trigger home loss. California's wildfire safety laws are expanding fast, and for many homeowners, they've become a hidden financial trap. New fire hardening requirements now demand specific upgrades, such as defensible space clearing, fire-resistant materials, roof modifications, and vegetation management. While these rules are promoted as safety measures, failure to comply can lead to fines, enforcement costs, and mandatory work orders placed directly on your property. If those costs go unpaid, they can become liens against your home. The real danger appears when insurance gets involved. If your home is deemed non-compliant with fire standards, insurers may cancel or refuse to renew coverage. Once insurance is lost, many mortgages immediately fall into default status, even if every payment is up to date. Lenders can then demand force-placed insurance at extreme rates or begin foreclosure proceedings. Homeowners are often shocked to learn that losing insurance, not missing payments, can put their home at risk. This law hits hardest in fire-prone and rural areas, where compliance costs can reach tens of thousands of dollars. Seniors, fixed-income families, and long-time residents may simply be unable to afford rapid upgrades. While California offers grants, retrofit programs, and appeal options, these require awareness, paperwork, and quick action. Enforcement timelines move faster than financial assistance. The most unsettling part is that homeowners trying to protect their property can still lose it, not to fire, but to regulatory pressure and insurance collapse. A law designed for safety can quietly become the pathway that forces someone out of their own home. Tell us in the comments, should losing insurance ever put a fully paid home in danger? Your opinion could change how others see these rules. We put real effort into uncovering laws that affect everyday homeowners. So support the channel by subscribing. It's just one click, and it helps us keep doing this work. Number 8. Inherited homes and probate delays that lead to foreclosure. In California, inheriting a home does not automatically protect it from being taken, especially during probate delays. When a homeowner passes away, property taxes, utility bills, HOA dues, and insurance payments do not stop. If ownership is not legally transferred in time, the home can quietly fall into tax default or enforcement status, even though family members fully intend to keep it. Many heirs assume they have plenty of time, but the law does not slow down for grief or paperwork. The danger comes from unclear legal ownership. During probate, there may be no single person authorized to make payments, dispute charges, or apply for exemptions. Counties and cities continue issuing notices, fines, and penalties, which may go unopened or be sent to the deceased owner's last address. Over time, these unpaid amounts can be converted into liens, triggering foreclosure or forced sale procedures before heirs realize the risk is real. This law impacts families across California, but it hits hardest when estates are modest and legal guidance is limited. While tools like transfer-on death deeds, property tax reassessments for heirs, and probate extensions exist, they must be properly filed and approved. Missed deadlines can erase protections permanently. The most heartbreaking cases involve families losing homes that have been owned for generations, not because they didn't care, but because the legal system moved faster than they could. An inherited home can go from a legacy to a liability if action isn't taken early and correctly. Comment below, should families ever lose a home just because paperwork takes time after a loss? Your thoughts matter more than you think. We invest real effort into explaining laws that affect real families, so support the channel by subscribing. It's just one click, and it helps us keep sharing this information. Number 9. Eminent domain expansion that can force you to sell. In California, eminent domain is no longer limited to highways and public buildings. It has expanded in ways many homeowners don't expect. New interpretations of public use now include housing developments, transit-oriented projects, climate infrastructure, and urban redevelopment plans. Under these rules, the government can legally force a homeowner to sell, even if they have lived there for decades and have done nothing wrong. What makes this law especially unsettling is that consent is not required. If your property falls within a designated project zone, officials can initiate eminent domain proceedings regardless of personal hardship, emotional attachment, or financial stability. While compensation is required by law, it is often based on government appraisals, not what it would cost to buy a comparable home in today's market. For many families, the payout simply isn't enough to start over in the same community. This law disproportionately affects working-class neighborhoods, seniors, and long-established communities where property values are rising fast. Notices can arrive suddenly, and once the process begins, timelines move quickly. Homeowners do have the right to challenge valuations and necessity claims, but doing so requires legal knowledge, resources, and time, things many people don't have when faced with sudden displacement. The most disturbing part is that this process is completely legal and framed as progress. A home doesn't have to be unsafe or delinquent to be taken. It just has to be in the way of a plan someone else decided was more important. Let us know in the comments. Would you accept being forced to sell your home for a project you didn't choose? Your answer could spark an important discussion. We put real research and effort into breaking down laws like this, so support the channel by subscribing. It's just one click, and it helps us keep exposing what others don't explain. Number 10. HOA super-lien powers that can override your mortgage. In California, Homeowners associations now hold some of the most aggressive collection powers in the state, and many owners have no idea. Under expanded HOA super-lien authority, unpaid dues, special assessments, or fines can escalate far beyond simple late fees. In certain cases, HOA liens gain priority status, meaning they can move ahead of your mortgage in the collection process. That's right. An HOA debt can threaten your home even when your mortgage is fully current. What makes this law especially dangerous is how small debts can grow into foreclosure actions. A few missed dues due to dispute, illness, or financial strain can trigger penalties, legal fees, interest, and attorney costs. HOAs often hire third-party collectors who move quickly and quietly. Notices may be sent by mail or posted electronically, and if deadlines are missed, the HOA can initiate non-judicial foreclosure proceedings without ever stepping into a courtroom. This law hits hardest in condos, townhomes, and planned communities, where HOAs control nearly every aspect of property management. Many homeowners assume HOAs can't touch ownership, only amenities, but that assumption is dangerously wrong. While California law does provide dispute resolution options, payment plans, and hardship protections, these must be requested early and followed precisely. Once legal fees pile up, resolving the issue becomes exponentially harder. The most alarming reality is that people have lost homes worth hundreds of thousands of dollars over relatively minor HOA balances. A system designed to maintain communities can quietly become the final mechanism that strips ownership from people who never imagined an HOA could hold that much power. Comment below, what's more shocking to you? An HOA outranking a mortgage, or losing a home over small dues? Your response could help others understand the risk. We put serious effort into exposing laws most homeowners never hear about. So support our work by subscribing. It's just one click, and it helps us keep making these videos. As you've seen, losing a home in California is no longer tied only to missing a mortgage payment. In 2026, the risks come from many directions: tax bills, utility charges, city fines, insurance rules, inheritance delays, court judgments, HOAs, and government projects. None of these situations start with reckless behavior. Most begin with confusion, missed notices, complex paperwork, or laws people never knew existed. That's what makes them so dangerous. The biggest takeaway is this: the system moves faster than most homeowners realize. Notices are mailed once. Deadlines are short. Penalties stack quietly. And by the time many people understand what's happening, legal processes are already in motion. These laws don't just affect investors or wealthy property owners. They hit seniors, working families, small landlords, and people who have lived in the same home for decades. Awareness isn't optional anymore. It's protection. But this video isn't meant to create fear. It's meant to create preparedness. Many of these situations can be avoided or slowed down with early action. Checking mail carefully, questioning unfamiliar charges, setting reminders, applying for exemptions, and seeking help before deadlines pass. The problem is not that protections don't exist. It's that they're rarely automatic. You have to know they're there to use them. If even one of these laws applies to your situation, now is the time to pay attention. Your home is more than a building. It's stability, history, and security. Understanding the rules that govern it is no longer optional in California. Staying informed is the difference between being protected and being blindsided.